thought this might be more fun to look at than just me reading or talking to you. So the truth is that throughout everyday life, people everywhere use and rely on common law to live and work together. It is simply the inherent way that people conduct their affairs. Liken it to the roots that bind together human communities by unconditionally upholding the life, dignity, and well-being of every man, woman, and boy or girl. These roots are foundational and become especially necessary in the face of tyrannical powers. The common law's firm horizontal guarantees of mutual respect and protection are a permanent threat to the efforts by arbitrary rulers to harness men and women into the unnatural and vertical arrangement known as the state. That is why every government and religion seeks to annul the common law with their own authority and statutes in order to reduce free people everywhere to the statutes of regimented, obedient, tax-paying wage slaves who serve a ruling clique. To extend our everyday reign of common law into all areas of life means to challenge the arbitrary rule of those cliques and of all state level regimes. But the very fact that common law serves we, the vast majority of people, means that it only needs to be consistently practiced by us for atrocities and oppression to crumble. We use the common law by simply employing and relying on it in all spheres of life. And that means by establishing common law courts of record with absolute jurisdiction over our lives and communities. Traditionally, law in the European tradition falls into two general categories, civil and criminal law. The former deals with disputes between individuals, often called tort offenses, or issues of negligence which cause harm. Criminal law deals with acts of intentional harm to individuals, but in a larger sense, are offenses against all people because they somehow threaten the community. Arising as a defense against absolutism and state or church tyranny, the common law traditionally has dealt with criminal law matters that crown or canon law courts refuse to address or do so in a restricted manner, including murder, rape, warfare, and other crimes against the community. But civil law matters of personal disputes may also be brought into a common law court, which, after all, claims universal jurisdiction over all legal matters within a community. Indeed, because common law is rooted in the jury system, what better forum can there be for the settling of civil matters between individuals than a trial before one's own neighbors? For our purposes, however, the major focus of litigation before our common law courts will be on criminal law and matters involving serious threats or crimes made against people, animals, communities, and the environment. As in any lawful system, the burden of proof in any such litigation brought before the common law court will be on the plaintiffs, those bringing the lawsuit. The normal rules of evidence will apply. For example, allegations against a party cannot be made in court without there being a basis in provable facts, such as primary documentation that is certified by an independent party or by producing eyewitnesses to the alleged crime. Another rule of evidence is the inadmissibility of hearsay evidence, as in, no, I wasn't there, but I heard. This is especially relevant rule when it comes to the commission of serious crimes such as genocide, murder, or rape. In short, any allegation must be backed up with provable facts and must be made by one who has a direct participant, was a direct participant in or an eyewitness to the event. For our purposes, it must be noted that in the case of especially monstrous corporate crimes committed by governments or other powers, such as wars of aggression, genocide, or human trafficking, normal rules of evidence are less stringently applied. This is because of a realistic understanding that crimes committed by entire societies or regimes are of a different nature than crimes by isolated individuals. A different set of norms regarding intent and provable evidence applies. In the words of the American prosecutor at the Nuremberg trials, in 1946, Robert Jackson. No regime that seeks the extermination of entire groups of people generally retains written proof of their intent to commit this crime. Considering the murderous nature of their regime, there is no need, since such extermination is not considered a crime. Nevertheless, even such a system seeks to fog and dissimulate the evidence, especially during warfare. The proof of crimes against humanity generally lies not in documents, but in the witnesses or the witness of survivors in mass graves and in the implied proof of the intent to commit these crimes contained in the everyday and institutionalized laws, attitudes, and norms of the murderous regime. End quote. Implied intent is a legal concept especially relevant and specific to litigation involving genocidal regimes, including governments and churches whose worldview and laws consider other groups to be unworthy of life or unequal rights, such as the churches and states that were tried and sentenced in the first case of the International Common Law Court of Justice concerning the genocide of Indigenous peoples in Canada. Laws such as the Indian Act of Canada, which impose a different set of laws on a racially targeted group, or the Roman Catholic Crimen Sola, wait, Solicitationis, Crimen Solicitationis, which condones and facilitates the concealment of child rape within the church, indicate a clear implied intent to commit and abet criminal acts. That is, it is unnecessary to prove the individual intent to harm children by Catholic priests, since under their own self-governing rules called canon law, every priest is systematically required to harm children by aiding those who do so if he is to retain his job and ordination. The collective guilt of these clergy as a whole is implied and clear, just as it was concerning all the servants of the Nazi regime. Thus, while normal due process requires that the prosecution prove that the accused committed an act and did so with deliberate intent, such an intent may also be assumed to exist by the larger context of a crime, especially when the crime is perpetuated by an entire organization or regime. Ascertaining the truth is always laborious, but ultimately the process is best guaranteed by a body of jurors than single adjudicators. Common law juries, and not individual judges, are a better guard against the abuse of rules of evidence and just procedure in a courtroom. Self-governing judges are notoriously prone to corruption and political manipulation, and when appointed by the very governments under criminal investigation, are obviously unsuited to the task of rendering a fair judgment. In fact, under legal procedure, such state-appointed judges have no jurisdictional competence to rule on the criminality and guilt of their employers. Judges routinely waive just procedure and rules of evidence and are authorized to do so by statute law. In Canada, Crown-appointed judges even have the power to alter or destroy court records, silence one party in a dispute, and ignore due process altogether. The whole point of establishing a jury-run common law court is to prevent such manipulation by the law and justice by unaccountable parties or vested interests. It is not accidental that a founding father of the American Republic, John Hancock, said in 1777, "If we have not courts that are established and maintained by the people rather than by corruptible judges, then we have no republic. Our Constitution and our nation will rise or fall according to the independence of our courts." Page 18. Canada and its churches, along with the sponsors in London and Rome, committed a deliberate and massive campaign of genocide against the Indigenous people, against Indigenous children for over a century. Under international law, such a criminal regime has lost its right to govern or expect allegiance from its citizens. From the verdict of the International Common Law Court of Justice in Brussels, February 25th, 2013. The common law's first principles establish its general legitimacy and lawfulness. This valid system gives rise to courts with the power to protect the people as a whole by prosecuting and indicting any persons and institutions that threaten the community. The mandate to establish such courts is derived from the sovereignty of the people as a whole, and not from any particular political system or government. Common law courts are therefore universal, not constricted by customary borders or laws, and possess the jurisdictional competence to adjudicate any issue or grievance. Common law courts are not subject to and do not recognize any other legal or political authority, immunity, or privilege like those routinely claimed by heads of churches and states. Enjoying universal jurisdiction because of its rootedness in natural law, common law courts can be established in any country or community, and not only within nations with a specifically common law legal tradition, such as Canada, England, and America. Common law courts are established when any number of men and women come together to judge a matter of concern to them and to their community. Political protests, town hall gatherings, or tribunals of conscience that unite people and give voice to their concerns are often the first step. common law courts are an expression of that voice. The court itself is established by the direct will and vote of the people as a whole, who gather in assembly and elect a citizen jury of at least 12 people. They also appoint a citizen prosecutor to conduct the case if needed, a presiding adjudicator whose job is strictly advisory, and a sheriff and a group of peace officers to enforce the summons, warrants, and verdicts of the court. Additionally, the community may appoint local magistrates versed in the law known as justices of the peace, who traditionally have the power to summon juries and issue warrants. The justice of the peace or a local sheriff may also initiate a common law court. All of the participants in a common law court must present their own case in all of the court proceedings, since to allow another to represent them would constitute a surrender of their natural rights and sovereignty. This applies both to the plaintiff and the defendants involved in any matter before the court. There are accordingly no professional lawyers or permanent presiding judges in a common law court system. There is no restriction on the power of a common law court to assess any person, place, or thing, nor any limitation on the duration of the rights of the court. The court and its magistrate can issue public summonses that are binding on any person or institution and enforceable by the court sheriff, who has an unrestricted right to detain any person named in the summons and bring them into the court. The final verdict of the common law court jury is final and not subject to appeal, simply because a reasonable and non-coerced group of citizens can come to the truth of any matter on the basis of the events alone, possessed as they are of an inherent knowledge of right and wrong. The truth is not mutable. The defendant is either innocent or guilty. The truth is not subject to revision or reconsideration, since then it is not true. However, if it can be proven beyond any doubt that the court's verdict was made unlawfully, was unduly influenced, or occurred on the basis of incompetence or faulty evidence, a common law magistrate can reopen and retry the case with the normal jury and court officers. In the same way, the sentence of the court is also final and is enforced not only by the court sheriff, but also by citizens, for the common law arises from and is the direct responsibility of all people, as are all of its procedures. The verdict really is a declaration of the people that they will govern themselves according to their own law and decisions. Finally, upon issuing its final verdict and sentence, the common law court jury is automatically concluded and its members are released from the duty. No court is maintained without the conscious consent and participation of the people themselves. Again, there is no professional permanent cast of either lawyers or judges in a common law court system, but rather elected and temporary court officers. Common law, being derived from natural justice, bases its legal procedures on the centrality of due process, the threefold right of anyone to be notified of the charges being brought against him, to see the evidence in such a suit, and to be tried and judged before his own peers. No legitimate trial can proceed, nor can a conviction be rendered if the accused has not been given these rights and afforded the chance to freely defend himself in the court of law. Such rights are based on these fundamental doctrines of the common law. It is presumed that the accused is innocent, not guilty. The burden of proof of the accused's guilt rests upon the defendant, but the plaintiff, who must convince a jury of the guilt of the accused beyond any reasonable doubt. And the accused cannot be detained without due process, but must appear promptly before a court according to the simple principle of habeas corpus, which is Latin for produce the body. Both sides in a dispute are given equal time to file their statements and evidence, make motions to the court, and respond to arguments. But to avoid vexatious litigation designed to simply harass or disrupt an adversary, which can drag out and impede justice and due process itself, the court normally sets a strict time limit on pretrial proceedings, after which the trial commences. The pretrial period allows both sides to present their evidence and arguments to one another in order to seek settlement prior to a court appearance. This presentation is usually referred to as examination for discovery, to see and say, where either party can demand any relevant evidence or document from the other. If examination does not produce a settlement of differences, then the court is convened and a trial begins. The general procedures and protocols of a common law court are summarized in the following outline, which must be followed by anyone seeking to accuse and try other parties. Step 1. Compiling the case. A statement of claim must be produced by those bringing a case, known as the plaintiffs. Their statement sets out, in point, form the basic facts of the dispute, the wrong being alleged, and the relief or remedy being sought. Next, the plaintiff's statement of claim must be accompanied by supporting evidence, documents, and testimonies, proving their case beyond any reasonable doubt. This evidence must be duly sworn by those not party to the dispute in the form of witness statements, and it must consist of the original documents themselves and not copies. As well, anyone whose testimony is used in this body of evidence must be willing to come into court to testify and affirm their own statement. Step 2, seeking the remedy of a common law court. Filing a notice of claim of right. After gathering his case, a plaintiff must then seek the aid of a common law court and its officers. Such a court can be brought into being by publishing a notice of claim of right, see Court Documents Appendix 4, which is a public declaration calling for the assistance of the community in the asserting of the plaintiff's right under natural justice to have his case heard through the common law by way of a jury of his neighbors and peers. Such a notice can be published in local newspapers or simply notarized and posted in a prominent public location like a town hall or a library. Step 3, forming a common law court. Within 24 hours of issuing of such a notice of claim of right, any 12 citizens of a community can constitute themselves as a common law court and its jury, and must then appoint the following court officers: a court adjudicator to advise and oversee the court, a public or citizen prosecutor to conduct the case. This person is normally the plaintiff himself or someone he authorizes to advise but not represent him, a defense counsel to advise but not represent the accused, a court sheriff, either elected from the community or delegated from among existing peace officers, bailiffs, a court registrar, and a court reporter. It is assumed that people with knowledge of the common law and legal procedure will act in these capacities, and as mentioned, a common law magistrate or justice of the peace may also initiate this formation of a common law court. Step 4, swearing in and convening the jury and court officers. Oaths of office. Upon the appointment of these court officers, the adjudicator, a justice of the peace, or a comparable magistrate will formally convene the court by taking and administering the following oath of the common law court office to all the court officers. I believe we would call them officials. I, John Doe, will faithfully perform my duties as an officer of this common law court according to the principles of natural justice and due process, acting at all times with integrity, honesty, and lawfulness. I recognize that if I fail to consistently abide by this oath, I can be removed from my office. I make this public oath freely, without coercion or ulterior motive, and without mental reservation. After taking this oath, the jury members, court counselors, sheriffs, bailiffs, and reporter will then convene and receive instructions from the adjudicator concerning the case. The adjudicator is not a presiding judge or magistrate, but an advisor to the court and has no power to influence, direct, or halt the actions or the decisions of the jury or other court officers, except in the case of a gross miscarriage of justice or negligence on the part of court officials. Thus, the court is self-regulating and dependent on the mutual respect and governance of the court officials and the jury. Step 5, pretrial conference. The adjudicator brings together both parties in a pretrial conference to settle the case prior to a trial. If a settlement is not achieved, both parties must engage in a mandatory examination or discovery where the evidence and statements of both sides will be presented. After a period of not more than 1 week, this pretrial conference will conclude and the trial will commence. Step 6, issuing a public summons. No person or agency may be lawfully summoned into common law court without first receiving a complete set of charges being brought against them and a formal notice to appear or writ of public summons. Such a summons outlines the exact time, date, and address when and where the trial will commence. The public summons is applied for by the plaintiff through the court registrar. The summons will be issued under the signature of the court adjudicator and delivered to the defendant by the court sheriff within 24 hours of its filing in the court registry by the plaintiff. The sheriff must personally serve the defendant or post the summons in a public place and record the posting if the defendant avoids service. The defendant has 7 days to appear in court from the date of service. So when you hear step 6 and you want to have a court in your state and you need a sheriff to give these public summons, it makes you think that you have to have at least a sheriff on the county where the court is going to take place. And this is just something that I'm kind of thinking about out loud when I read this. Step 7. After an introduction by the adjudicator, the trial commences with opening arguments by first the plaintiff or prosecutor and then the defendant. The adjudicator and both counselors will then have the chance to question either parties for clarification and to make motions to the court if it is apparent that the proceedings can be expedited. Note, step 7 can still occur even if one side, usually the defendant, is not present in court or refuses to participate. Such a trial being conducted in absentia remains a legitimate legal procedure once the defendant is given every opportunity to appear and respond to the charges and evidence against him. And an absentia trial will commence with the plaintiff presenting his opening argument, followed by his central case. The court-appointed defense counsel will then be given the chance to argue on behalf of the absent defendant, if that is the wish of the latter. It is often the case that a non-response or non-appearance by the defendant can result in the adjudicator advising the jury to declare a verdict in favor of the plaintiff on the grounds that the defendant had tacitly agreed with the case against himself by not disputing the evidence or charges and by making no attempt to appear and defend his own good name in public. Step 8, the main proceedings. Assuming the proceedings are not being conducted in absentia and the defendant is present, the main proceedings of the trial then commence with the plaintiff's presentation of the details of his evidence and argument against the defendant, who can then respond. The plaintiff may be assisted by the citizen prosecutor. After his presentation, the plaintiff is then cross-examined by the defendant or his advising counsel. Following cross-examination, the defendant presents his case with or without his advising counselor, and in turn is cross-examined by the plaintiff or the citizen prosecutor. There are usually no restrictions placed on the duration of the main proceedings. Step 9, closing arguments and summaries to the jury and final advice of the adjudicator. After the main proceedings, the adjudicator has the chance to further question both parties in order to give final advice to the jury. The plaintiff and the defendant then have the right to give their summary argument to the court. The adjudicator closes with any final comments to the jury. Step 10. The court is held in recess while the 12 citizen jury members retire to come to a unanimous verdict and a sentence based on their appraisal of all the evidence. There is no time restriction on their deliberations, and during that time, they are not allowed contact with anyone save the court bailiff, who is their guard. The jury's verdict and sentence must be consensual and unanimous. And we have learned in the common law book by Brent Allen Winters that if you do not agree, you cannot be coerced and bullied into going along with everyone else. So if 11 people truly feel one way about the whole thing and they all agree with one another, the 12th man does not have to agree, and therefore it is a hung jury, and they do not have a verdict or a sentence. So that is very possible. No one can be forced to agree and go along with something that they don't believe. Step 12, the court adjourns and the sentence is enforced. Step 11. The jury issues its unanimous verdict and sentence. The court is reconvened after the jury has come to a verdict. If the jurors are not in complete unanimity concerning the verdict, the defendant is automatically declared to be innocent. The jury spokesman chosen from among them by a vote announces the verdict to the court, and based on the verdict, the final sentence is also declared by the jury or jointly with the adjudicator. Step 12. Following the announcement of the verdict and sentence, the adjudicator either frees the defendant or affirms and authorizes the decision of the jury in the name of the court and instructs the sheriff to enforce that sentence. The adjudicator dismisses the jury and concludes the trial proceedings. The complete record of the proceedings is a public document accessible to anyone, and it can in no way be withheld, altered, or compromised by the adjudicator or any other party. A note to common law enforcement. It is understood that every able-bodied citizen is obligated and empowered by natural law to assist the court sheriff and his deputies in enforcing the sentence of the court, including by ensuring the imprisonment of the guilty, the monitoring of his associates, and the public seizure of the assets and property of the guilty and his agents, if such is the sentence of the court. This collective law enforcement is required in the interest of public safety, especially when the guilty party is an entire institution or head officers of that body.